hour of your afternoon with us, especially on this snowy day for everyone in Boston. My name is Michaela, and my partner for our presentation today is Ariel. One of the biggest topics that clients come to our clinic for is entity formation. And oftentimes, our clients are trying to decide between a limited liability company, LLC for short, or a corporation. And sometimes there's so much information on the internet that you have all these different puzzle pieces, yet it can be difficult to put them all together. So today we're going to help you put the puzzle pieces together on how to decide between an LLC and a corporation and what the main differences are between the two.
So for a brief agenda, we're going to start with an overview on the different types of entities, and then walk through the key considerations in deciding between an LLC and a corporation. We're then going to touch upon differences in forming an LLC or a corporation. And finally, our clients tend to have concerns on what is required of them and their company after formation. So we will walk through the differences in post-formation requirements as well. And at the end of our presentation, we have some examples to help you put all the pieces together. We also have saved time for questions at the end of our presentation, but feel free to enter your questions into the chat as we go, and we'll try to get to them if we can before the end.
All right, so let's start with entity types. There are 4 entity types you have likely heard of: sole proprietorship, partnership, LLC, and corporation. We're going to quickly walk through those so you have an understanding of what exactly those are. Let's start with what our clients typically come to us as: sole proprietorship or partnership. You do not have to actually file anything to form these entities. A sole proprietorship is a single person who owns or controls a business for profit. Some of you on the call may control a company that has not formed an LLC or corporation. You, as the sole owner, are the sole proprietor. This is the most common business form. One data point thinks that 75% of all US businesses are sole proprietorships. In a sole proprietorship, the single owner pays all taxes and debts personally. The downside to this entity type is the owner has unlimited personal liability. This is one of the main reasons why we urge you to come to our clinic, so we can protect you from personal liability. A partnership is 2 or more people who carry on as co-owners of a business for profit. In this scenario, absent an agreement to the contrary, all owners have an equal voice in the conduct of the business, have the power to bind the partnership, and share equally in the business's profits and losses. Furthermore, in a partnership, taxes pass through directly to the owners. Again, this type of entity faces unlimited personal liability.
So our focus today will be on limited liability companies, which we'll call LLCs, and corporations. So we're going to briefly touch on the key aspects of the two, and then we're going to dive into these more deeply during our presentation. So hopefully if you have questions that pop into your head from this slide, we'll end up answering them later on. So a limited liability company is a flexible enterprise that blends elements of partnership and corporate structures. A corporation has an independent existence as an entity. An LLC is created when articles of organization are filed in the state under whose law the LLC is formed. Similarly, a corporation is governed under different statutes depending on the state of incorporation, but corporations are most commonly incorporated in Delaware, and we will explain later on why Delaware is the most common for this. With regards to taxation, LLCs have what's called pass-through taxation, which we'll also get into later on, as opposed to a C-Corp that has double taxation. And S-Corps are taxed as a partnership. Just to briefly touch on what an S-Corp is, an S-Corp can only have 100 shareholders maximum and 1 class of stock. And further, S-Corp investors cannot be entities and must be US citizens or permanent residents. So for that reason, our clients typically do not form S-Corps, which is why when we say corporation today, we're going to be meaning C-Corps. However, if you are eligible to come to the clinic, we'd be happy to discuss all these options based on your unique needs. 2 other important aspects that we are going to go into more detail about are investor preferences and equity or stock.
You may be asking, when should I think about forming an entity? So when you have a bank account or you are taking on liability where you may be entering into agreements. If you have a business more tangible than just an idea, then we recommend forming an entity. Again, the important factor here is limited liability. Until you form an entity, you are personally liable for any debts incurred or even tort liability, which if someone, say, uses your product and then is harmed by it. In short, limited liability is one of the most important reasons why you should form an LLC or corporation. So what exactly is limited liability? Well, limited liability is just that, limited. Limited liability generally shields you from personal liability for business failings that aren't related to illegal activity, willful negligence, or the personal wrongdoing of you or co-owners. You can, however, still be liable if what was done wrong was done by you. You can be liable if you sign something that says you are liable, or if you are the person that committed the negligence. If you would like to protect your personal assets and limit your personal liability, then you will likely want your company to be an LLC or corporation. Otherwise, owners are personally liable. When considering choosing between a corporation or an LLC, liability considerations do not factor into entity choice because liability benefits are applicable to both a corporation and an LLC. There are four main areas of personal liability aside from taxation. Liability on operating contracts, such as leases and franchise agreements, liability on long-term debt owed to banks, financial institutions, and individual debt investors, liability on short-term debt owed to creditors on accounts, and liability for injuries and damages to third parties. An LLC provides its members with limited liability, just like its name says. The entity's obligations are solely the entity's. LLC members protect personal money and assets not invested in the business. Although it does not say it in its name, a corporation also provides limited liability. A corporation shields its shareholders, directors, and officers from personal liability for the obligations of the corporation. When entering into contracts, officers and directors should fully understand that they are acting as agents of the corporation, that they should sign documents or checks only in their official corporate capacity as agents of the corporation. Otherwise, the director or officer may incur personal liability. So now to the good stuff, what you should consider when deciding between an LLC or a corporation. There are three main factors we will walk through: taxation and income treatment, investors, and equity.
So first, taxation and income treatment. A corporation is considered a separate taxable entity, and because of this, files its own federal income tax return to pay federal income tax on its taxable income. After the corporation pays federal income tax on its earnings, the shareholders and employees must pay tax on their dividends and wages. This is called double taxation because the IRS code effectively taxes the corporation's earnings twice, once at the corporate level on the entity's taxable income, and once again at the shareholder level to the extent that the corporation distributes that income to shareholders in the form of dividends. This is not usually an issue for startups we see because they do not have dividends. A dividend is a distribution to shareholders of company earnings. It's rare for most startups to issue these dividends, and they're typically distributed in much bigger companies. So therefore, double taxation becomes a larger burden for much bigger companies. And corporations actually have more tax deductions available that the corporation can take at some levels. Now turning to an LLC. An LLC is most often taxed like a partnership. Therefore, income and losses pass through the entity to members, who pay tax on their share of the entity's taxable income at the member's individual tax rate. All income is taxed to the members when earned. Members may also elect to have the LLC taxed as a corporation if they would like. A related concept to LLC taxes is allocations, which is how income tax items like taxable income, deductions, and credits are allocated among the LLC members, and a system is in place in LLCs to track these allocations and identify which members are responsible for the LLC income. The default rule related to LLC allocations is that allocations are made in proportion to the member's interest in the LLC. So, for example, if member A has 75% interest and member B has 25% interest in the LLC, member A is responsible for 75% of the income, and member B is responsible for 25% of the income. Another thing to know about LLCs are distributions, which are independent of allocations. A distribution occurs when the LLC distributes cash or other property to its members. Where LLC allocation provisions deal with allocating tax items among LLC members, LLC distribution provisions deal with the distribution of cash to the members. By default, distributions are made in proportion to the member's interest in the company, similar to allocations, but this default rule can be changed in the operating agreement. Distributions in an LLC are comparable to dividends in a corporation in that you cannot make a distribution when the company is insolvent. As a clinic, one issue that we try to anticipate and help our clients avoid is phantom income. An LLC allocates its income to its members each year, and the members have to report their share of the LLC's profits on their tax return, even if the LLC makes no distributions to its members. This creates what is called phantom income, which is income that is treated as having been earned and taxable to the member, even though no money flowed into the LLC to pay the taxes.
If you're like me, then you love the show Shark Tank. And if you dream of pitching your company to the sharks or are just considering investors, then the CCorporation is often considered the most attractive entity to angel investors and venture capitalists. There is no limitation on the number of shares in a CCorporation. A corporation allows for different classes of stock and therefore can create preferred stock. Preferred shareholders have priority over a company's income, meaning they are paid dividends before common shareholders. The CCorporation is particularly attractive to venture capitalists and angel investors because of that preferred stock and the ability to issue stock options. Investors also prefer the corporation be formed in Delaware. Delaware's business code is one of the most flexible in the country and is generally perceived as being management friendly. Further, the Delaware Court of Chancery focuses solely on business law, so the judges there are experienced in that area. Investors are also more comfortable with the Delaware Corporation just because they are more familiar with them, and corporations offer a better exit strategy. This is not to say that investors do not invest in an LLC. Investors will consider how big of an investment you are seeking and what type of relationship the investor would have with the company. This is something that we discuss with our clients a lot, and if you are eligible for the clinic, we would be happy to talk you through this in one of our intake meetings, and we will explain how you can schedule an intake meeting at the end of our presentation.
Corporations divide ownership with stock, which represents equity in a corporation. So in a corporation, we see founders' equity, and a typical startup corporation that intends to raise outside angel and/or venture capital funding will issue shares to the founders. So taking a look at an example, let's say the new company authorizes 5,000 shares and there are two founders, founder A and founder B. Each founder is issued 2,000 shares. Collectively, the founders will initially own 100% of the company. However, by starting with 5,000 shares, a single share will not have a lot of value and still leaves 1,000 shares authorized but not issued. So because there are only 4,000 shares issued, the 5,000 minus 4,000 is 1,000. Until you choose to issue the rest of those shares, the only owners of the company are founder A and founder B. That gives the company flexibility to issue additional equity to the early team without having to amend the certificate of incorporation. And we'll discuss exactly what a certificate of incorporation is later on. So a benefit of having a corporation is that corporations lend themselves to employee equity incentive plans. An incentive stock option allows you to incentivize employee good performance, reward advisors, and reward the company for long-term growth. As discussed on the previous slide, corporations can have different classes of stock, such as preferred stock and common stock. A board action is required to create a class of stock, and then you must file in the state of incorporation. LLCs can also have stock that looks like preferred stock. The process around it is just a little bit different. Turning to LLCs, LLCs can grant what we call ownership interest in the LLC, sometimes represented as units, which are a member's share of the profits and the losses of the limited liability company and the right to receive distributions of the limited liability company's assets. One of the principal differences between equity in a corporation compared with equity in an LLC is transferability. Stock in a corporation is generally transferable. If I transfer you stock in a corporation, you become a shareholder. And then the reason for an LLC may be good for limiting membership interest transferability and why you may want this is because you may not want people having access to documents of the company or to bring a derivative lawsuit against the company, which is something that shareholders have the right to do. In an LLC, you can separate who has management rights and who has economic rights. There can be any kind of transfer restrictions with ownership interests in an LLC. In the Delaware LLC statute, there are a couple of things that only members have the right to do. For example, only a member can bring a derivative action lawsuit or demand access to LLC's records. Therefore, you could grant someone an ownership interest, but they do not have the power that a member does.
So now on to the third puzzle piece, differences in formation. Once you've decided between an LLC or a corporation, the documents needed to form the entities differ. On this slide, you will see bullets indicating what documents are needed. These documents are going to sound very legal, and our clinic, if you are eligible, often does these formation and post-formation documents for clients. So Ariel and I are going to explain what they are, but please know that if you are eligible for the clinic, we will likely prepare these for you and walk you through them in greater detail. The first step in forming a corporation is to prepare the Articles of Organization or a Certificate of Incorporation, also called a charter. The state corporate statute will contain what provisions should be included, such as corporation name, registered agent, and how many securities the corporation has the authority to issue. On the other hand, an LLC is formed by filing a certificate of formation and required fee with the Secretary of the State, and those fees do differ by state. Both a corporation and an LLC require a registered agent. A registered agent's purpose is to provide a legal address within the state where there are persons available to facilitate legal service of process in the event of a legal action or lawsuit. If you are thinking, wait, I wanted to form an LLC or corporation in Delaware, but I don't have someone there to be a registered agent, that's okay. We can actually provide you with a registered agent in Delaware for a fee. Next, we prepare a consent of sole incorporator, which is the owner handing the company off to the board. The sole incorporator is approving the filing of their certificate of incorporation, is approving the corporation's bylaws, and is naming the board of directors of the corporation. On the other hand, for an LLC, we prepare a consent of authorized person, which is a clean record where the authorized person, often the founder, consents to persons being named initial members of the company. And one question we are often asked is, and similar to the one that I see in the chat, is can I convert an LLC to a corporation if I change my mind later? And the answer is yes. One of the advantages of forming an LLC is that the LLC can generally convert into a corporation tax-free. It is more difficult to convert from a corporation to an LLC due to tax issues. Many states allow a simplified process when converting from an LLC to a corporation, known as a statutory conversion. With a statutory conversion, you can automatically transfer the LLC's assets and liabilities to a corporation without having to separately form a corporation and dissolve the LLC. It is also fairly simple to convert specifically a Delaware LLC to a Delaware corporation, which we see quite a bit in the clinic. And this is something to consider as a later action if you want flexibility, as this question in the chat points to change the entity.
So now you've made your decision, you've formed your entity, what's next? Well, there are some requirements after you form an entity. So we're going to walk you through the differences between a corporation and an LLC regarding documents, management structure, boards and meetings, and duties. And one of the big differences that we will talk about throughout this section is that LLCs offer more flexibility than corporations. Looking first to documents, different types of documents are required and used for different types of entities. These would be the type of documents that our clinic can help you with. A corporation also requires an initial director consent, which is the first consent of the directors. The directors approve the sole incorporator's actions, appoint officers, approve forms of certificates, approve the fiscal year, approve bank and tax actions, foreign qualification, stock issuance, and management powers. Although an LLC requires an initial manager or member consent, it essentially does the same things that an initial director consent does. It can approve bank-related and tax-related matters, authorization of agreements, and providing for admission of additional members. Corporate bylaws delineate the rights and authorities of the shareholders, directors, and officers of the corporation. They provide rules and processes as to how the company will be run. Typically, bylaws describe matters like how shareholder or director meetings are called, how much notice has to be given before a meeting, and what constitutes a quorum for an effective vote. They may also include qualifications for directors and functions of board committees. A shareholders or a stockholders agreement is something that the clinic and some companies use, although it is not a requirement. A shareholders agreement is a contract between the shareholders of the corporation that outlines the roles, rights, and responsibilities of the shareholders, and also how the company should be operated. The goal of a shareholders agreement is to ensure that the shareholders are treated properly in order to protect their rights. For example, it may outline how and who will get to make decisions about purchasing property, distributing dividends, how to pay back a loan that was borrowed on behalf of the business, or what will happen in the event that the business wants to dissolve. It protects against only a few members of the corporation making this kind of choice. And while I mentioned that only some companies and the clinic use a shareholders agreement, many of these rights that I just mentioned can be in the charter and in other documents of the corporation. So it is still important to think about protecting these things and where your company should do so. A share purchase agreement is an agreement that defines the terms and conditions relating to the purchase and sale of a company's shares, which is also an important document for corporations as they will have shareholders buying and selling their shares. The LLC agreement is an agreement among members governing the LLC's business and the members' financial and managerial rights and duties. In Massachusetts, it is called an operating agreement, so that's likely how you'll hear us referring to it throughout the presentation. This agreement often embodies provisions from all the corporate documents. State statutes have default terms if there is no operating agreement, so even if members don't have an operating agreement, there are still rules to be governed by. We, however, always recommend a formal LLC agreement. So looking to documents that both have, so one concept that can apply to documentation in both corporations and LLCs is vesting. Vesting is a process that gives the company the right to repurchase a percentage of the founder's equity, shares or interest, depending on if it's a corporation or LLC. And this is called the unvested percentage in case the founder leaves the company before a certain time. So a founder's shares will vest based on a vesting schedule. For example, on a standard 4-year vesting schedule, 25% of the founder's shares will vest each year, usually in monthly increments. Once the shares vest, the company no longer has the right to repurchase those shares. Standard vesting schedules also often have what's called a 1-year cliff. So due to this cliff, a founder must stay with the company for 1 full year before the first increment of their shares will vest. So under the 4-year vesting schedule that I just described, none of the shares will vest until the 1-year mark, at which point 25% of the shares will vest. So after the first year, the remainder of the shares will vest in monthly increments, such that at the end of the 4 years, all of the shares will have vested. Both LLCs and corporations may make 83B elections in certain circumstances. As some background terminology, restricted stock is owned but subject to being taken away if it does not vest, whereas a stock option is a right to buy a certain number of shares at a certain price in the future. An 83B election permits the holder of restricted stock to elect to be taxed on their stock once it has been awarded, rather than waiting until it fully vests. So an 83B election is a form filed with the IRS that allows owners to avoid paying taxes on the future of their company by letting the IRS know that you would like to be taxed on the date your equity was granted to you, rather than on the date the equity vests. So it accelerates your ordinary income tax. You can only use 83B elections for stock that is subject to vesting. So grants of fully vested stock will be taxed at the time that it is granted. So, for example, for an LLC with interest subject to vesting, they will need to send in 83B elections just like a corporation. If this concept seems confusing, don't worry, this is also something that the clinic or attorneys can help you with.
So now we're going to discuss management structure, which can seem a bit daunting when you're talking about people's titles within a company, but please know it's actually straightforward. On the corporation side, you have a board of directors, officers, and shareholders. Shareholders own the company and elect a board of directors. The board of directors manages the business and affairs and appoints officers. Officers run the day-to-day operations. Think president, treasurer, and secretary. LLC's management structures are flexible in that it is determined by the operating agreement. You almost always have the option to contract differently, but if your operating agreement is silent, then you look to state statutes. That's different from corporation statutes, which guide how a corporation has to be run. The two most common management structures for an LLC are member managed and manager managed, which we will explain on the next slide. Before we get into the member managed compared to manager managed, let's clarify some LLC lingo that you may have caught on to so far. Owners of an LLC are called members, which may include individuals, corporations, other LLCs, and foreign entities, and there is no maximum number of members. Members have the authority to bind the LLC. Most states also permit single-member LLCs, which are LLCs that have only one owner. An LLC with 2 or more members is considered a multi-member LLC. So LLCs can be member-managed or manager-managed. Member-managed LLCs are where all the owners, members, participate in running the business. Member-managed LLCs are most appropriate for startup businesses in which there are only a few people who are all active in the business and hold ownership interests. In a manager-managed LLC, members elect managers that have authority similar to that of a general partner. Managers can be certain designated members, non-members, or a combination to run the business. A manager-managed LLC is most commonly preferred when some managers only want to be passive investors in the business and not have management responsibilities. If there are only a few people active in your business and you are thinking of a member-managed LLC, one factor to consider is whether you think you may want to expand to more members in the future. A manager-managed LLC will make adding members or managers easier later on. Otherwise, a move from manager-managed to member-managed will require a more intensive edit to the operating agreement. And a point we keep coming back to is flexibility with LLCs. And this is a great example of what we mean. LLCs can give corporate titles. You can call managers officers if you want, or you could call them vice presidents, but not a manager.
So boards and meetings. Corporations have processes that must be followed. There must be notice for board meetings and notice for shareholder meetings. If you get written consent, sometimes states require written consent to be unanimous. Corporations also require directors' meetings and annual shareholders' meetings, which may also require record-keeping obligations and minutes to be documented. While this list may look like a lot, most of this will not be too burdensome for you in reality. Initially, all of the shareholders, or the founders, will be meeting together often. You will likely have calls together every couple of weeks at least, so an annual meeting will not be too hard. In terms of an LLC, LLC meetings are largely a matter of contract. There is no obligation in an LLC to have meetings unless you contract to have them. If members have to agree on something, that can be in writing. No formal meeting with advance notice is required. It is a good idea, however, to keep records regardless of requirements. You may choose to add requirements like meeting numbers and record keeping in your operating agreement when you form an LLC. It's just not statutorily required like it is for a corporation. And one exception is if you have a Massachusetts LLC, there are also record-keeping obligations, but they're minimal in the grand scheme of things. So one thing that founders care about is the extent to which other owners might come back and complain about how they run the company. These other owners may try to make life difficult for you as founders or even make a claim against you. So directors of a corporation must follow what's called the business judgment rule, which is a presumption that directors have made decisions in good faith with the care that a reasonably prudent person would use and with the reasonable belief that the director is acting in the best interests of the corporation. The business judgment rule provides the directors with a lot of leeway and flexibility in their decision-making. A fiduciary duty is an obligation to act in the best interest of another party. So when discussing fiduciary duties in this context, we are expecting directors and officers to act in the best interest of the corporation. You cannot eliminate fiduciary duties for a corporation. Members and managers of LLCs similarly have fiduciary duties of care, loyalty, good faith, and fair dealing to the membership and each other. Unlike corporations, depending on the state, duties of care and loyalty may be restricted or eliminated by LLC operating agreements. So there is much more flexibility to contract around these.
Okay, so now that we've gone through the key aspects of the entity types, including the differences between LLCs and C corporations, we thought we would give some hypothetical situations and show you how the choice between the two entities may play out in real life and in some situations that you may find yourself in. So we're going to read each hypothetical scenario and give you a few moments to put your best guess in the chat. And there may be no right or wrong answer, so just try your best. Normally, we would get more information from clients specific to their venture in deciding between the two. So for our first hypo, Alpha is a new startup. The founders do not expect needing any outside investors and do not want to be held to formal requirements like when or how often to meet. So we'll give you a few moments to put your answer in the chat. Yes, so thank you guys for participating. This may be better as an LLC because outside investors are more likely to prefer a C corporation due to tax complications and more certain equity distribution. If Alpha doesn't think it needs outside investors, they don't have to be as locked into choosing a C corporation. In addition, we have discussed the more set of formalities regarding meeting times for corporations, which are more flexible in LLCs. So an LLC is likely the better choice for Alpha here. For our second hypo, Beta's founders want to look into venture capital funding and are in an accelerator program that takes equity. The key here is venture capital funding and the accelerator program. Yes, exactly, guys. So Beta should probably go with a corporation. As we discussed in the previous hypothetical situation, VCs generally prefer corporations for reasons including that they are more familiar with them, they may want preferred stock, which corporations can offer, they like companies to issue stock options, and corporations offer a better exit strategy. This is because options such as an IPO or VC firm selling their interest to someone else are both easier with corporations. C Corp shares are freely transferable, while there are restrictions on the sale of LLC interests. An accelerator program that also wants to take equity would prefer a corporation for the same reasons. Although LLCs may issue membership interests, these are different than stock options in corporations.
So moving on to hypo 3. 2 MIT students have started a 2-person marketing consulting business. So let me know in the chat what you think about this one. So that seems to be right. It is likely better off forming an LLC. This choice would be good because unlike a partnership, which we talked about at the beginning of the presentation, which is an option for a two-person business, you would get the limited liability advantage of an LLC, where you're shielded from personal liability for business failings that aren't related to illegal activity, willful negligence, or the personal wrongdoing of you or the co-owners of the LLC. And further, a consulting service is typically better suited to be an LLC rather than a corporation because there's money coming in right away to the business. Therefore, you get LLC flexibility and do not have to worry about the complications of income going to the corporation, then to the founders, and then being given out as income or dividends. And so for our last typo, Gamma's 3 founders started a business. They may want to add additional key employees in the future. When forming an entity, the founders want to give the future employees equity that allows them to share only in the appreciation of the company after they join. Let me know what you think about this one. Yes, we've got a few corporation answers in there. So because C corporations can issue employee stock options, this would likely be the best choice for Gamma. Corporations can issue incentive stock options, which allow employees to defer tax on the equity compensation that they receive until they ultimately sell the underlying stock that is subject to the stock options. LLCs can reward their employees in the form of membership interest in the LLC, but it is a little more complicated than it is for corporations, and certain types of equity compensation, such as incentive stock options, are not available for LLCs. Gamma's desire to only give future employees equity that allows them to share in the appreciation of the company after they join also means this would make more sense as a corporation through something like a vesting schedule that is definitely available to corporations and gives the option to increase the amount of an employee's ownership over the course of the employment at the company.
So thank you so much for spending your time with us today. We hope we were able to shed some light on the questions that led you to this presentation. On your screen, you should see a link to our clinic website. We have some great resources on the site for you, and soon this slideshow will also be posted. And as a plug for our clinic, if you are an eligible MIT or BU student, feel free to fill out an intake form so we can meet with you and help answer your unique questions. Forming a corporation or an LLC with the clinic will cost between $300 and $500 based on filing fees. And since we still have some time, we'd be happy to take questions, and you can feel free to put them in the chat or raise your hand and we can unmute you.
Yeah, just to answer the first question there, if you click on the link to our website and to fill out an intake form, we can connect. And so the $300 to $500 is what the filing fee is going to be. So our clinic is free.
So to answer how much is a Massachusetts registered agent from the clinic, I'm not sure off the top of my head. However, if you are in Massachusetts, you can be the registered agent.
Yeah, the reason we focus on talking about registered agents in Delaware is that we assume that almost none of our clients are actually located in Delaware. And so they can't be their company's own registered agent there. But if somebody's in Massachusetts, you don't need to pay a service company to provide that for you. And I'll go ahead and take the follow-up question on registered agent about personal address, because I don't know if Ariel and Michaela have really looked at that before. But on that question, yeah, the registered agent's address would be public. You know, and we also recommend that you not use a dormitory address or something like that because of how transient our clients are. But yeah, you would have to do that. You know, frankly, in the time I've been here, I haven't had any student startup that said they would rather pay a registered agent in Massachusetts than to do it themselves for free. But if you're concerned about the address, certainly the kinds of companies that do that, the cost range is going to be in the same range as in Delaware. It's going to be, you know, between $100 and $200 a year probably to serve as your registered agent.
For the question for initial investment requirements, I don't believe there are any legal requirements for an LLC, at least. I'm not positive about a corporation.
Yeah, this is not like in Europe and other places where companies have to have a minimum capitalization. There are generally no requirements like that for U.S. entities.
And then to answer the question, is it more cumbersome to form an LLC in New Jersey first and then convert it to a C Corp in Delaware later on versus forming a C Corp from the start? Due to the process of converting an LLC to a C Corp and the filing fees involved in that, it is more cumbersome. But if an LLC is the right choice for you, we wouldn't want you doing a corporation if an LLC is the right choice for you. It is easier to convert from a Delaware LLC to a Delaware C Corp, but you still can convert, say, a New Jersey LLC to a Delaware C Corp.
Yeah, and this is completely random, but I'm not 100% sure that New Jersey has a conversion statute. And I know that only because I'm on a listserv and somebody posted that question about 3 hours ago and nobody has answered it. So he was asking to be pointed to the New Jersey conversion statute if there was one, and nobody has answered the question. So I'm not 100% sure that starting in New Jersey and converting to Delaware actually works.
And so from my understanding for the question, if for a small startup, suppose it makes $100,000 in revenue and owners are paid its wages, is the corporate tax avoided? It's in effect only in the case of dividend payments. So wages count as it's wages or dividends that count as the kind of double taxation part of that. So you still have the double taxation part of the corporation's taxes.
Yeah, but Ariel, let me just throw this in here because I think this is what they were asking. You know, what you're saying basically, Rashab, is that there's $100,000 in revenue, but there's also $100,000 in deductible employment expenses for the company. So the company isn't making any profit. You don't pay tax on revenue, you pay tax on profit. And so you're saying there's no profit at all. So yeah, I think you're right. You wouldn't pay any corporate income tax, but what you would do by paying out everything in wages is you would pay, you know, the full tax at the employee level on the employment income, and you would also, you wouldn't really pay $100,000 in wages because the company would have to pay its own share of Social Security and Medicare tax. So you'd be paying something less than that in wages. You still wouldn't have any profit, but you would be paying that exactly. You'd be paying that 7.65% times 2. So you're paying the 15.3 plus the income tax. And that's the way you ought to be looking at the total tax burden.
So for the question, can I form a Delaware LLC with a New Jersey address, or do I need a registered agent in Delaware? So the address of the LLC can be New Jersey, but you still need a registered agent for service of process. So you could use your New Jersey address, and then we would also provide you with the registered agent in Delaware.
Yes, so to the question, is it possible to have the corporation being incorporated, I'm assuming, in Delaware and have an office in Massachusetts, yes, you can. And it's fine to do that as long as you have a registered agent in Delaware.
But what if the second part, Ariel, if you are doing business in Massachusetts, and that's the complicated question, but having an office is not going to help your argument. If you actually have an office and you're doing business in Massachusetts, you probably should be registering the company in Massachusetts as a foreign entity. But there are some de minimis things you could be doing in Massachusetts that wouldn't rise to the level of doing business. But if you were advertising or listing a Massachusetts office on a website, for example, that would not help your argument that you don't have to pay Massachusetts as well. Yeah, Rashab, you probably ought to look at a company like Amazon. Now, I realize they have a lot of warehouses everywhere and they perform delivery services now everywhere on their own. But if you looked at any other sort of digital company that was selling services or products, if they're based in Massachusetts and their data is flowing through Massachusetts, it's likely the Massachusetts are going to try to grab their annual fee. Mikhail and Ariel, you want to take that recurring and initial filing cost question?
Sure. So each state has its own fees for formation. So that is more specific to each state. But within Massachusetts and Delaware, those costs are the same. And ongoing fees can be different. The franchise tax in Delaware is $300 for an LLC, and between $175 and $450 for corporations. And then the annual fees come out to about $300 to $500 when you account for a registered agent. So they are comparable, but there are slight differences.
Good questions, everybody. And just remember, if you, if you've got a lot of specific questions like that, even if you're not ready to start a business, you can sign up and we'd be happy to do an intake interview and try to talk through some of those as well in your meeting with the students handling the intake interview. So feel free to do that. And we posted the links, I think, a couple of times already in the chat. And you can just Google BU Startup Law and find us as well.
Yeah, we also have a lot of resources on our page. I know Mikhail posted the upcoming presentations, and we also have a lot of just kind of informational resources, past student presentations. This will also be posted, and some papers that students have written on topics that may be helpful for you to look into. Yeah, so I think that would just be a conversion from an LLC to a Delaware corporation. And as we mentioned, while it's easier to do it from a Delaware LLC to a Delaware corporation, it is possible.
Yeah, it's a little trickier than going Delaware to Delaware, though. Anybody have any other questions for these guys? Oh, there's one.
So I can take the question from Rashab. Can a LLC or corporation have owners or shareholders not present in the US? So that's one of the benefits and why we kind of recommend against an S Corp, because for that you wouldn't be able to. There are some specific immigration laws that pertain to if someone is actually doing work. Between an LLC or corporation, you can both, it's similar laws in terms of what you're allowed to do. But that's something that if there's a specific person who is working for you, they may need to speak with an immigration attorney to make sure that the work that they're doing complies with all of our laws.
Yeah, Rashab, on the which is better question, I don't think it really turns on where the owners of the company are. The only time that comes into play is if you're talking about somebody who's like right now, if you were on a student visa and you were living in your home country but planning to come back to Boston later, we might have a conversation about what's better if you're on an F1 visa, but generally speaking, there's not a big difference. Giuseppe, I'm not sure what you're asking about in terms of online taxation, online transaction taxation. If you're talking about sales tax and things like that, that's sort of beyond the scope of what we're doing, what we do in the clinic, but we can certainly point you to resources there. Giuseppe, why don't you just send an email to the link that's on the webpage, and we can sort of point you to that. But it would be helpful to know exactly what kind of taxation you're asking about, and we can, there may be some charts out there and things like that that we could point you to. All right, everybody. If nobody's got any other questions, we'll go ahead and let Michaela and Ariel go. I really appreciate their job here, and appreciate you guys coming to the presentation.